This courtroom clip you're about to see, it unfolds in just 12 seconds, from a routine traffic stop to a taser deployment, a young woman, a pair of brass knuckles, and a police stop that escalated faster than anyone could react. But here's the twist. Was this a case of justified force or a misunderstanding fueled by fear and attitude? Stay tuned, because by the end of this hearing, the judge will say something every driver in America needs to hear.
And frankly, I don't know what to make of it. This whole thing went down in 12 seconds. You got pulled over, the officer got out of the car, and 12 seconds later, you were on the ground.
He followed me for a minute before he pulled me over. And when I got there, there was more officers. I didn't know what was going on.
Well, you started out right off the bat with the attitude. It's like, why are you following me? You've been following me for two and a half miles. Lynn McRoberts, file number 533FY, alleges no insurance and possession of the metallic knuckles. Defendant pled to no insurance, forfeited the brass knuckles. The matter was set for sentencing today. I don't know. That warrant had been out for a while, I guess. In file number 251158, that occurred this year, June of 2025.
Right here, the judge has already watched the body cam footage multiple times, and even he seems baffled. 12 seconds from stop to takedown. That's lightning fast. Notice how he highlights the defendant's attitude, but also admits there was no evidence of assault. This moment sets up a classic courtroom dilemma. Where does non-compliance end and excessive force begin? Viewers, what do you think? Should a disrespectful tone justify a taser?
While they were serving that earlier warrant, the defendant was charged with resisting and obstructing a police officer, pled to attempting to resist or obstruct a police officer, and no valid operator's license. So the defendant is scheduled for sentencing for 2 traffic violations and a felony attempted resisting, obstructing a police officer, reduced to a misdemeanor. Ms. McNeese, I told you that I would get the police report, Ms. McRoberts, and watch the video with the assistance of the prosecutor's staff. They're always very helpful. I got the video, and frankly, I don't know what to make of it. This whole thing went down in 12 seconds. You got pulled over. The officer got out of the car, and 12 seconds later, you were on the ground. From the body cam video, I get another perspective of it. You weren't the most respectful. You started out with the MF, and once that happened, you were on the ground. But whatever you did was within seconds. Resisting and obstructing or assaulting includes all of those things. There's no evidence that you assaulted the police officer. I guess resisting and obstructing is not complying with their lawful commands, but I've certainly seen a lot worse than this. It was helpful to see the video. Anyway, having said all that, Mr. Knopfsinger, what would you like me to know?
Yeah, I would like to know the court is aware that she was tased.
The taser detail changes everything. Defense claims confusion, prosecution calls it justified. But here's the key. The judge can't even tell who fired the taser from the footage. That ambiguity raises a serious question about accountability. When law enforcement actions are unclear, who bears the responsibility? The officer, the suspect, or the system that trains them?
During this as well. So,
yeah, I couldn't tell who tased her. All of a sudden, I didn't know if Officer Marsh, who was also there, did the tasing. It all happened. So,
who walked up to the car door is the one who tased me.
I think it was Hoggard.
Hoggard?
Yeah.
All right. It all happened so fast. It was, and I watched it several times, and I couldn't tell. At any rate, That didn't sound like any fun. Then you were a hornet. You were threatening to sue everybody and dropping the F-bombs and, but up to that point, you said you're not even going to ask my name or anything. And then wham, bam, you're on the ground. So, Mr. Officer, what would you like me to know?
Well, it happened very, very quickly. I know for some people too, I run into this sometimes too. People don't know what they can and can't do. And with the lawful order, and the resisting and obstructing statute is one of the most expansive criminal statutes that includes a wide range of conduct, as the court noted, assaulting, physically pushing or injuring an officer, all the way to disobeying a lawful command, which can include getting out of a motor vehicle. And I've encountered this recently. People don't think that they have to get out of a vehicle if there is a valid traffic stop, and that is the case. I can understand. I reviewed the body cam. I initially got the case, and yeah, there was a lot of anger. It did happen very quickly. She was tased. She went to jail. I would ask the court to consider that. She has made some changes, Judge. I haven't spoken to her. I think she regrets the conduct and now understands the importance. And also reading the police report, I don't know if she knew sort of what was going on before all of this went down too.
This is the missing puzzle piece. Police weren't just pulling her over for no insurance. They thought she was fleeing an assault scene and had a weapons warrant. Imagine being the officer, thinking you're stopping an armed suspect, or being the driver, unaware you even had a warrant. That misunderstanding created the perfect storm. Two people, two versions of reality, both colliding in 12 chaotic seconds.
Well, there was something that preceded it. There was some sort of an assault in progress, a dogwood at Klinger Lake, and someone alleged that she was the assaulter and had just left the area. So that's why they were pulling over in the first place.
Yeah, I think that added to sort of from law enforcement's perspective, sort of the urgency.
Well, and she had an open warrant for carrying concealed weapon. So, but the weapon was a dumb pair of brass knuckles, but you couldn't tell that from the lean dispatch that she just had a CCW, meaning you think it's a gun.
Right.
So she's a suspect and assault if she has an open warrant for a weapon charge. And the officer was having that in his background at the time.
Yeah, I can understand that maybe there was not so much patience, to put it gently, Judge. So,
Yes.
She is set to move into a new apartment and getting the kid ready for school. So I get the sense from her that this isn't going to happen again, Judge.
Yes.
So I would ask the court to consider all those in fashion. Thank you.
So the charge way back when was no insurance, the 2023 case, and possession of metallic knuckles. That was during Mr. Marvin's administration, and rather than do an arrest or issue a citation, the officers would submit a warrant request and they would get a warrant. So you got stopped on February 5th of 2023 for having no insurance. And they said you were in possession of a pair of brass knuckles. That's a felony. It's punishable by up to 5 years in prison. So they sent it to the prosecutor and they issued a warrant in April of 2023. My guess is you didn't even know there was an open warrant for your arrest. From April of 23. Did you continue to live on Riverside Drive?
No, I was at the homeless shelter when that incident happened with brass knuckles.
All right. So anyway, there's a warrant out from 2023 that you don't even know about. Somebody calls about this disturbance out near Klinger Lake, and they realize there's an existing warrant for your arrest. So they dismissed the brass knuckles and you pled to not having insurance. That one carries a minimum fine of $200 up to $500 plus costs. So we'll address that one in a minute. In the other case, the one that's more of a concern, that's from June. The most concerning charge is the attempted resisting obstructing. Assistant Prosecuting Attorney Angelique Camfield is here on behalf of the prosecutor's office. Ms. Camfield, what would you like me to know?
The prosecutor nails the legal logic here. From their perspective, the officer's fear was justified. Open weapons warrant, hidden hands, and possible contraband. In training terms, that's a high-threat stop. But what's fascinating is her framing. She calls tasing the least aggressive way to control the scene. It's a chilling reminder of how differently law enforcement and civilians interpret danger in the same instant.
Your Honor, I've had an opportunity to review the defendant's criminal history, which doesn't appear to have anything of significance up until these particular instances. I will note that the report indicates that the officer, in addition to being aware of an open felony weapons offense warrant, did also indicate that there was a passenger in the vehicle and there were furtive movements being made before the vehicle came to a stop. Now, in the training and experience of an officer on the scene, that could indicate a number of things. On the top of their minds is usually there's drugs and or weapons being hidden while the stop is being made. So if she's refusing to get out of the vehicle, as she later did, and then starting to put her hand behind her back, as the report indicates, where he is unable to see it, that is what led, according to his police report, to the taser being deployed. He has somebody with an open weapons warrant and her hands where he can't see them, at least one of them, and another person in the vehicle, and he doesn't know what they may have hid prior to the stop. So I think that in that circumstance, being tasered is certainly not anything anyone would want to occur, but that was perhaps the least aggressive form of controlling the situation for the safety of everybody involved in this particular instance. I think that that needs to be taken into consideration with respect to the sentence. When somebody is being given a lawful command, a lot of these situations can be avoided if you just comply with the lawful command and not argue about whether you should or should not do it, or whether they can or cannot have you step out of the vehicle. No. If there's a concern about that, bring it up with their superior later, but maintain your safety and the safety of the situation by complying with the officer on the scene. That did not occur here. Now the question is, do we need a probation period in order to make sure that this doesn't occur again and to rehabilitate and deter others from this type of behavior? I'll leave that to the discretion of the court. It seems that a short period would be appropriate in the circumstances. And I will say, particularly given the fact that she just left the scene of a disturbance where there was an alleged assault as well.
Yeah, and I can't really do anything with that. There were no charges. It's all unconfirmed.
I will note that part of the plea agreement in getting this reduced to a misdemeanor was forfeiture of the brass knuckles.
Yes. All right. How'd you get here?
My dad.
All right, good. Your driving record isn't bad. Your driver's license is just expired. So you need to do what you need to do to get your license back. It doesn't appear to me that you're prohibited, but you just didn't have a license either on that day or now. Where's your dad?
In his truck.
He didn't want to come in and watch any of this? All right, what would you like to tell me?
I didn't know I was doing anything wrong. He came up to the car, reached his hand inside my car and told me to get out. I didn't know what was going on. He followed me for a minute before he pulled me over. And when I got there, there was more officers. I didn't know what was going on.
Well, there's Kleenexes right there.
It was the only day I didn't have a licensed driver with me.
Well, you started out right off the bat with the attitude. It's like, why are you following me? You've been following me for two and a half miles. Well, he was following you because and you didn't know that there's an issue of what he knew and what you knew. He knew there was an open warrant for your arrest for a weapons charge. You didn't even know that warrant even existed. 2, he was reported your vehicle was involved in some sort of an assaultive disturbance a couple miles away, which he knew and you didn't know. So you got 2 people that are not on the same community.
This is the heart of the judge's reasoning. He admits she had an attitude, but also that she didn't know about the warrant or the prior allegation. This moment underscores how communication failures can spiral into criminal charges. He even says, "I've certainly seen worse." That line reveals his empathy. He's not excusing her behavior, but he recognizes how quickly chaos replaced understanding.
Communication level. You did have an attitude, but it all happened so fast. You started with the MF, and that was when it was wham bam. So I've certainly seen a lot worse. The problems are going to be how much this is going to cost, because there are several things involved here. Are you employed right now?
No,
When did you last work?
5 months ago.
Where was that?
The Indian Camp of Nazarene in Vicksburg.
One of my sons went to that camp with another kid. He didn't like it there much a long time ago. Have you been looking for a job?
No, I'm a stay-at-home mom. My boyfriend works.
You owe me a bunch of money.
I can get it to you.
Okay. I'm not going to order any additional jail. And I'm not going to order any probation. The prosecutor says that's in my discretion, and she's right. You didn't do anything other than have a bad attitude. This brass knuckles was under the category of DUMB. You didn't need any brass knuckles, and you didn't know that was a 5-year felony to possess them. But that was the felony charge, which resulted in this. Don't know what the dispute was. Somebody called the cops. This was a real nice car. Whose car was
My
this?
dad's. He gave it to me. It's gone now.
It was a Challenger?
No, it was a 2014 Mustang.
Oh yeah, Mustang. It was in good shape. Anyway, so what happened to that?
My dad tried to get it out, and they said.
Oh yeah,
somebody
you
sold
told me
it.
it got impounded and never was redeemed. Is that right?
Yeah, because I guess I left the scene of a crime, so they told me I can't have it back.
Regarding this
Yeah,
or something else?
this. I've been trying to get a hold of somebody to get it out of impound, and nobody will call me back. All I know is there's a hold on it. My dad told me today that they sold it. It's going to public auction or something.
Yes, I don't know. There was no reason for a police hold on this car. Well, all right, then the R&O fine is $0. $125 crime victims' rights fee, $50 state minimum fee, $150 attorney fee, which is $275, part of a payment plan. 1 day jail credit, 1 day. Let me see if I have any bond. Judge Pattison gave you a PR bond, so I don't have any money in any of these files. So if we add everything up, 225 and 275 is $500 plus $75. Total is $575. How much can you pay each month?
Probably 100.
All right. I'm not ordering any additional jail time, but you gotta set up $100 a month payment plan. The court officer take you out to the court office. You set up the payment plan. Pay this off. That'll take about 6 months at that rate to pay it all off. And I guess my only advice would be what Judge McManus used to tell people. Even when the police officer's wrong, he's right. And the best answer to the police officer is yes, sir. Yes, ma'am. And do what they ask.
And there it is. No jail, no probation, just fines and a firm warning. The judge's closing advice: even when the police officer is wrong, he's right. A controversial but practical truth in courtroom reality. Compliance often keeps you safe, even when you disagree. This case shows how 12 seconds can define your future. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns, only here on Celeb Mafia Courtroom Chronicles.